Support for WUWM podcasts comes from Potawatomi Casino Hotel Milwaukee, home to 24/7 excitement, dining, and an on-site hotel at 1721 West Canal Street. More information at potawatomi.com.
Lake Effect brings you conversations about what's happening in Milwaukee and the people, places, and organizations that shape the community. This is Lake Effect Spotlight from WUWM, Milwaukee's NPR.
Wisconsin has about 400 miles of Lake Michigan shoreline, but a dispute in Shorewood has ignited a debate about who has access to that shoreline. The village of Shorewood maintains people have access to the public Atwater Beach, but residents with homes to the north and south of the beach own everything down to the water's edge. A Shorewood resident challenged that policy in municipal court earlier this month. The judge said she'll be announcing her ruling by the end of the first week of January. This debate has been going on for decades and has been settled in other states, according to David Strifling. He's an associate professor at Marquette University's law school and directs its water law and policy initiative. Strifling joins WUWM environmental reporter Susan Bence to explain the Public Trust Doctrine.
Going back to antiquity, it seems that there's been a sense that the public should have the right to access navigable waters. And going way back to Roman law or English common law, that may have been mostly focused on transportation and trade and commerce and those kinds of purposes. But as we've advanced through time, it has been expanded to other rights as well, like recreation. And so when we look at Wisconsin, there are a lot of different sources for the Public Trust Doctrine, but really it starts with the English common law through to the Northwest Ordinance, which governed the Northwest Territory before Wisconsin even became a state. And then the language from that document was incorporated into the Wisconsin Constitution. That's where we stand, and the difficulty has arisen in terms of interpreting that language that's in the Wisconsin Constitution and is a little bit vague.
Can you share some of that language?
Sure. So what the Wisconsin Constitution says is that the Mississippi River and the navigable waters, and that's an important term, navigable waters, leading into the Mississippi and St. Lawrence, and the carrying places between the same shall be common highways and forever free, not only to the inhabitants of Wisconsin, but also to the inhabitants of the United States. So anyone who comes here would have the freedom to use those navigable waters.
So when Wisconsin became a state, was it given the lake beds? Is that part of our origin story, and what does that mean? Is that an element of the public trust?
So it's a slightly different legal doctrine called the equal footing doctrine. And at the risk of getting too far into the weeds, what the equal footing doctrine says is that any new states coming into the Union of the United States have to enter on an equal footing with the original 13 states. And the original 13 states all held title to the beds underlying the navigable waters in those states because they inherited it from the English crown when they got independence. And so based on that equal footing doctrine, when Wisconsin came into the Union, yes, it inherited the title to the beds underneath all of its navigable waters to be held in trust for the public. So the equal footing doctrine sort of is operationalizing or making possible the public trust doctrine.
Back to the language.
Right, so it's pretty vague. I think the key difficulty is how do we operationalize what it means to be common highways and forever free? Does it mean access? Does it mean the state can't sell that land or give it to a private party? Does it mean there's some restriction on what a private property owner can do with their land? Wisconsin has a mix of all of those things, and basically what's happened here is that our legislature has designated the DNR as our trustee for the public trust doctrine and the public trust lands in the state. And the DNR has to figure out exactly what it means for the public to have that right on a day-to-day basis. And that's why we've got 150 years of case law from the Wisconsin Supreme Court and the Wisconsin Court of Appeals trying to determine exactly what the public right is in those navigable waters.
I'm just guessing that a case like this that brought about our conversation happening to be in Shorewood, where somebody walked from the public beach onto what is considered private land north of that beach. So Lake Michigan in and of itself hasn't risen to, or access to the shore, let's say, or the beach, has not been taken up by the Wisconsin Supreme Court?
Lots of people have asked me that question, and it seems hard to believe, right? Because it's such a relatable scenario. There you are, walking along the beach. Suddenly you turn to the side and see that there's private homes there, and you wonder, do I have the right to be here or not? And you're right, I'm not aware of any case that directly addresses that question with the factual scenario that we have here. And the only thing I can analogize it to is it's like watching a baseball game or a football game, and you've been watching a lot of baseball or football over the years, but you see some play that has never happened before, and there's always something new under the sun.
You've said there's been a lot of case law around the navigable waters and access to it over time in Wisconsin. Is there a case that you find most applicable to this situation?
Not really, and here's the problem. It is that you can pull language, and I'll do so in a moment, from just little snippets from one decision or another that may seem to point one way or another in terms of which way this case should come out. There are some cases that say that the public trust right rises and falls with the water, in perfect harmony with the natural order of things. As the water rises, the public's right rises. But then there are other cases, and some are more recent than others, that say that the ordinary high water mark is the boundary of the public's right, that anything between the ordinary high water marks on either side of a lake or a river, the public has the right there, the better right, but above the ordinary high water mark, the private landowner has the better right. So it's very difficult, and that's why you see these cases possibly going to the Court of Appeals or the Supreme Court, because both sides have good arguments here that they can root in the Wisconsin Supreme Court's precedent, depending on which case and which part of a case. And sometimes some of the language is taken in isolation, where it really needs to be considered in context. So, I couldn't say that there's one case that I would look at and say that's the one we should really follow in terms of this Shorewood dispute.
Can you give us a taste of the kind of language that you found in various cases having to do with navigable waters?
I think the key distinction here is, do we want to determine these rights based on the ordinary high water mark, or do we want to determine them based on where the water is at any particular moment in time? And so that's where I cited those cases previously, where some seem to point in the first direction and others seem to point in the second. And so there are really three scenarios here, but the first thing we've got to do is define the ordinary high water mark. What does that mean? The DNR says some things about that in terms of how you would look at the shoreline and notice a shelving effect, for example, where the geology changes a little bit, or you could look and see where the vegetation changes maybe, or where there is debris or trash that's been left by the water as it rises and falls. All those things could be keys or indicators of where the ordinary high water mark is. On the other hand, I think part of the reason that DNR has adopted this sort of wet feet doctrine, that you're not trespassing if your feet are in the water, is it's just easier. You can just look at the ground and see where the water is. There's no dispute possible about that as compared to where exactly you place that ordinary high water mark. So, three different scenarios we could think about here. One would be where the water is above that ordinary high water mark. It's sort of at a flood stage. The other would be where the water is at the ordinary high water mark. That's the easiest case, right? Everyone would agree that those 2 points are the same in that case, and the public's right is anywhere below that, anywhere lakeward of that. And then the third is the Shorewood scenario, where the water is below the ordinary high water mark and there's some stretch of dry beach in between. So that's what we've got to determine here and sort out from the case law is, are we going to key things based on the ordinary high water mark or where the water's edge is at any particular point in time?
We've had the opportunity to talk in the past, and you mentioned another element of the debate is the riparian owners.
So what the courts have said about property ownership in Wisconsin and elsewhere nationally really is that one of the most important rights that a private property owner has is the right to exclude others from their property. If you don't have that, you don't really have private property because anyone can come there. What we have here is a scenario or a situation in which that private property right, the right to exclude others, is clashing or at the very least colliding with the public's right to access navigable waters. And the question is, how are the courts going to draw those lines between where the private right ends and the public right begins and vice versa? And courts in other states have done different things. Some have said that the private right ends at the ordinary high water mark and anything below that belongs to the state and the public. And others have said that there's some overlap here where there could be some coexistence perhaps of a private right and a public right. And that's a little bit more difficult to unpack. Obviously, it's not a bright line rule. But right, this is a question of property rights, really, between the public right and the private right.
Michigan and Indiana, who share the Lake Michigan shoreline, they had cases that rose to their Supreme Courts, and there is now access for the public along their stretch of Lake Michigan shore. So is it surprising to you in any way that our Lake Michigan shoreline access hasn't been addressed before this time?
It's surprising in some ways and not in others. The Indiana case was decided, I think, in 2018, and the Michigan case in 2005, if memory serves. So it's not like these cases date from 1900 or 1872. I mean, these are pretty recent cases, too, indicating that this is kind of a new issue, at least, that's coming up in the courts of some of these states. So, on one hand, there's that. On the other hand, there's the eminently logical point or practical point that this must happen all the time, and why haven't we seen this decided in our courts before? So I don't have a good answer to that last question. What's really interesting, too, is how the Michigan and Indiana courts got to those results. The Michigan court took a very practical path and essentially said, this plaintiff just wants to walk along the lakeshore, and she needs the right to do that in order to enable or to exercise her more traditional public trust rights like boating and fishing and hunting in the navigable waters of Michigan. If you can't walk along the shore, the court thought, makes it a lot more difficult to access and enable and exercise some of those other public trust rights. So a very practical analysis. On the other hand, the Indiana Supreme Court took a much more legalistic, formalistic approach to this, starting with the equal footing doctrine, which we talked about earlier, that says that the state of Indiana, in that case, took title to all those lands, those beds underlying the navigable waters at statehood, and it's never relinquished them, never legislatively relinquished them to private owners. So that means that you go up to the ordinary high water mark, and whether it's exposed at that moment or not, that's the boundary. So even if there's some stretch of dry beach between that ordinary high water mark and the water level at that point in time, you still look at the ordinary high water mark because that's the property analysis that the court went through. So really different pathways, but they get to the same point, which is public access to that dry beach as long as it's below the ordinary high water mark.
David Strifling is an associate professor of law and the director of the Water Law and Policy Initiative at Marquette University Law School. You can learn more about the case in Shorewood at WUWM.com.
You can find more interviews like this one by visiting WUWM.com/Lake Effect. And while you're there, subscribe to the Lake Effect Spotlight podcast.